Good morning, everyone. Kyle Schiedo, personal injury attorney at Collins, Gann, McCloskey, and Barry. We usually have some new people at every meeting, so I was just going to give a brief background about myself. I'm a former Nassau County Assistant District Attorney, meaning I was a prosecutor. I prosecuted anything from DWI crimes to vehicular assaults, as well as neighbor disputes and petty theft, anything like that. Started out in misdemeanor court doing DWIs and general offenses. Did about a dozen trials there before I was promoted to the search warrant rotation, where we work on very high profile investigations in the office. And from there, I went to grand jury presentment, probably presented about 100 grand jury cases within a few months, and then eventually doing felony trials in the Vehicular Crimes Bureau. That career really led to me leaving the DA's office to join a firm, Collins, Gann, McCloskey, and Barry, where I now practice primarily criminal defense and personal injury. Another fact about myself is that I am an adjunct professor of law at Hofstra University, where I teach trial advocacy to law students from first-year law students all the way to third-year students competing nationally. So let me tell you a little bit more about what I do as a personal injury attorney. There's generally three categories that my practice focuses on. The first being premises liability. This can be anything from what most people know as a slip and fall, whether it's at a supermarket, a business, private residence, a publicly governmentally owned premises. My firm will evaluate those cases, and we do handle those. We also do dog bites. I actually received a call a few months ago about a woman who was concerned about her dog who had bit somebody who was antagonizing it. Turned out not to be a case. We were able to defend her and keep the whole thing out of court. In addition to those two premises actions, there's also negligent or insufficient security on premises. This is usually with bar security or security at what you would think of like an event. Unfortunately, with the COVID situation, that seems far less likely than some of these other possibilities in the given times. And then the last premises liability, just general category, is a failure to warn guests of potential hazard. These are cases typically where somebody is having new construction done at their home. They invite somebody over to the property, and they owe a duty to that person entering on the property to warn them of construction being done, whether their deck is torn apart, or this door has a sudden drop if you were to try to open it, or we're building a pool in the backyard. That's the general premises liability. Most people think of that as slip and fall, if that's easier to remember. I also primarily specialize in auto accidents, and a lot of my training and experience from the district attorney's office feeds into this part of my practice. I've done accident reconstruction courses. We've analyzed data from the black boxes from the cars, and I've prosecuted these types of cases, so that helps tremendously when it comes to investigating and building a case. I wanted to give some general information about these types of cases that I think would be helpful, since most likely people here will be in a car accident at some point or another. Hopefully it's only a minor accident with no injuries, but if you are injured in a car accident, there is something called no fault, meaning regardless of who's to blame for the car accident, there is a process where after a reported accident, you receive paperwork almost immediately from your insurance company asking you to fill out no fault coverage. It's very important that anyone in an accident goes through no fault. It can reduce your recovery. And this is something that I think people should have a general understanding of. You have to have insurance to have a car on the road. By having insurance, every insurance company has to have no fault coverage in New York State. So almost every car on the road has this. I say almost because there are cars out there that are not properly insured, which means they cannot be properly registered, and so they should not be on the road to begin with. But the reason no fault is important is it gives you your first 50,000 towards basic economic losses, and basic meaning wages and medical expenses. So no fault will cover your wages up to 80% of what you are making, with a cap of $2,000 per month. It's non-taxable, much like unemployment is non-taxable income. That is providable until you reach the cap of 50,000, as long as you are missing work as a result of a car accident. The same is true for medical bills. If you are still injured and receiving treatment that is causally related to a car accident, those medical bills are covered by no fault for life or until that 50,000 limit is exhausted. The reason there's that The reason there is that $50,000 limit is because of this next part that we're getting into, which to have a high number value case for an auto accident, New York has what some people have described as an archaic system where you need what a qualifying injury, also known as a serious injury. So there's going to be a lot of car accident type cases that I receive phone calls about, where it's a wait and see whether they meet the threshold. And I wrote out the 8 criteria to meet that threshold. As a side note, this does not apply to motorcycle accidents. They receive a different type of coverage. But just to understand why a lot of the phone calls and questions I get about car accidents take time before we can start a case is because somebody either needs to be dead, there needs to be dismemberment or disfigurement. All of those sound incredibly gruesome for you to apply to meet this serious injury threshold. Some of the other ones are a little bit less serious. A fracture, those can be pretty common. Loss of an unborn child or a fetus is a qualifying criteria. Permanent loss of the use of any bodily organ or function, or permitted limited use of any bodily organ or function. And then the last catch-all, this is where a lot of cases tend to land, and that's where you go 90 of the first 180 days after you're not able to do all of your daily functions as you normally would. So a lot of times in auto accident cases, it's good to get a hold of an attorney right away. They can guide you through the no fault process of just what paperwork to do, how to move forward from the immediate accident, and then provide advice for how to go to appropriate doctor's appointments, see whether there's going to be a qualifying serious injury threshold, and then file a suit on your behalf. The last practice area that my firm does and that I specifically do is products liability. There's 3 general categories for products liability. Manufacturing errors, that's when a product was designed and when built properly doesn't have a defect that's going to cause harm to a person. But in this case, maybe they made the wall of the gas tank too thin and it spilled and caught on fire. Or they simply just had something go wrong while building the product, and as a result, it was unnecessarily dangerous. The second main category is a lack of or inadequate warnings. I remember learning about cases where a Jeep company had an advertisement where the Jeep was driving off-road. People were buying the Jeep expecting that they could drive it off-road. There was a rollover event. The vehicle could not handle the rollover, and the 2 passengers inside the vehicle were killed. That was a lack of adequate warnings. The Jeep company was found to have failed to warn that the vehicle's rollover bar would not support off-road travel. The third main category is defects in design. That's when a product is just built wrong. I think I told you about a case that I personally handled where a police officer up in Buffalo had his firearm in the police assigned holster. The holster left enough space for his finger to actually reach in and pull the trigger of his gun while he was unbuckling his vehicle, or his seatbelt while in his police car. He discharged his gun, luckily didn't shoot himself, but suffered deafness in one ear and hearing loss in the other for an extended period of time. That is a defective design when it's not designed properly to protect you from those safeties. Those are the three general areas I practice in: premises liability, auto accidents, and products liability. Does anyone have any questions?